Gaurav Jain, and I thanks Taxmann for providing me an opportunity to discuss the recent decision of Delhi High Court in a batch of matters which is under the cause title of Suman Jeet Agarwal. This decision, friends, is another feather in the cap on this continuing saga of the amended provisions of Section 148, read with 148A of the Act by the Finance Act 2021 after the decision of Supreme Court in the case of Ashish Agarwal. The controversy in this case is with respect to the date of issue of notice under Section 148 through the mode of electronic stroke digital mode of communication. As we all are aware, today the notices are issued and served through the electronic mode of ITBA server and then coupled with service through the email. So what is the date of issue or what is the date of service of this notice? That was the controversy in this decision. I'll come to the nitty-gritties of this decision in a while. But friends, before we go to that, this decision, the ratio emanating from this decision will not just be restricted to this controversy of 148, but will have bearing on routine matters relating to service of orders or other notices through the digital mode of communication with which we grapple on a day-to-day basis. So as part of this talk, when we will conclude, we will see the ramifications of this decision not only on the controversy of 148 but to provisions other than 148 as well. So with that, coming to the decision, friends, the controversy in this decision was that notices under Section 148 prior to amendment by the Finance Act 2021 were issued with date 31st March 2021. The notices under Section 148 were dated 31/3/2021, which were received by the assessees on or after 1/4/2021 by email or by uploading on the portal, and then the notices were either with the digital signatures or were without the digital signatures. So the controversy was, what is the date of issue of notices under Section 148 when these are received by the assessees on or after 1/4/21, while these notices are dated 31st March 2021. Friends, under the erstwhile provisions of Section 149 as well as under the new provisions of 149, for the purposes of 148, when we are to count the date of limitation, the important word is what is the date of issue of notice. It is not service of notice but date of issue of notice. So for instance, if the time barring for assessment year 14-15 is 6 years from the end of the assessment year on 31st March 2021, then notice under Section 148 has to be issued on or before 31st March 2021. It may be served at a later date. But if it is issued after 31st March 2021, it will become time barred as per the erstwhile provisions of Section 149. So that is the importance of the word issue. Now in these batch of matters, what happened was, while the notice date was 31st March 2021, which makes it within the period of limitation, but the emails were received by the assessees on or after 1/4/2021. So the issue was whether just because the notice is dated 31st March 2021, can it be said that notice is issued on that date while it leaves outside the servers of the income tax department, email servers of income tax department, and received by the assessees on or after 1/4/2021. So that is the broad controversy that was there before the Delhi High Court in this decision. There were several other facets on this digital mode of communication. It was not only that the notice was dated March 2021 and received by email on or after 1/4/2021. The other facets were that certain notices were digitally signed. The date of digital signature did not match with the date of notice. Certain notices were not even digitally signed. The date of uploading on the ITBA portal was different than the date of receipt by email by the assessees, etc., etc. So these were the various facets. The Delhi High Court framed different batches, different categories of these notices, where all these notices lie, like there was a separate category of notices which had digital signatures, separate category of notices which did not have digital signatures, so on and so forth. Now coming to the ratio of this decision. Now the first issue that comes in this digital mode of communication is the difference between uploading of the notice on the ITBA server. After uploading, it is sent by email to the registered email address of the assessee. So the question is whether the date of uploading on the ITBA server can be said to be the date of issue or service of notice, or it is the date of email which will be relevant to decide the date of issue or service. Now the High Court held that the provisions, substantive provisions of the Act which pertain to 148, read with section 282 of the Income Tax Act, which prescribes the mode of issue and service of various notices and orders under the Income Tax Act. Section 282 takes us to the Information Technology Act and says that in the electronic era, the mode of issue and service prescribed in the IT Act will be interpolated in the Income Tax Act and will be considered as the mode of communication. Now, when we go to Information Technology Act, read with the Income Tax Act, there is no cognizance of uploading of 148 notice on the ITBA portal. It is just a facility provided when on shifting of the modes of communication through the electronic mode, but there is no statutory recognition of ITBA portal for the purposes of section 148. What 148 recognizes is only mode of service as per the Information Technology Act, more particularly section 13 thereof. As per section 13, it is only the email, and that too when the email moves outside the servers of the originator, that is the Income Tax Department. That is the date that will be considered as the date of issue. The High Court held that there is a difference between the date of generation and date of issue. The date of generation could be the date of digital signature or date of uploading on the ITBA portal. But the date of issue / dispatch, read with section 13 of the Information Technology Act, is only the date when the email moves outside the server of the originator, that is the Income Tax Department. It may be received by the assessees later, but when it moves outside the server of the Income Tax Department, that will be considered as the date of issue. And for this purpose, that the date of issue means date of dispatch, the Delhi High Court took support from the earlier decisions which were rendered in the case of date of when the mode of service was through registered post. In the erstwhile decisions, it was held that mere signing the notice is not the date of issue, but it is when the notice is given to the postal department for service to the assessees. It is that date which will be considered as the date of dispatch and date of issue. So therefore, taking clue from the erstwhile decision of manual dispatch, the High Court came to the conclusion that even in the digital era, read with section 13 of the Information Technology Act, it is only the date when the notice is dispatched, moves outside the servers of the Income Tax Department, that date will be considered as the date of issue. Now, if that date fell within the period of limitation of 31st March 2020-21, those notices were valid. If the notice, although is dated 31st March 2021, although it is digitally signed on 31st March 2021, but if it is, although by way of auto mode or by way of direct punching of the email by the assessing officer or through the automated servers of the Income Tax Department, if it moves after 12 noon, after 12 midnight of 31st March 2021, then it will be considered as being issued on 1/4/2021. So what is the repercussion of the notice to be considered as being issued on 1/4/2021? As per now, if the notice is considered as being issued on or after 1/4/2021, then that will be considered as the date of issue. So only those notices which are not time barred on 1/4/2021 will become valid. And then the decision of Supreme Court in Ashish Agarwal would come into play. And as per that decision, those notices will be considered or deemed as notices being issued under the new provision as under 148A of the Act, show cause notices under 148AB of the Act, and then the entire jurisprudence that follows the decision of Ashish Agarwal, that is, as per the new law, if the income escaping assessment is more than 50 lakhs, then notices for certain time period will be valid. If the income escaping assessment is less than 50 lakhs, then notices for certain assessment years will become time barred, and vice versa. So that is the fallout of the importance of the date of issue of notice. That's first, friends. That is, ITBA uploading of the notice on ITBA server is not valid. It is the date of email and the date when it moves outside the coffers of the income tax department. That date is available in the records of the income tax department. That date can be checked, can be asked from the assessing officers, and if that date falls after 12 midnight of 31st March 2021, then the new law will apply. If it is not, if it is just before 31st March 2021, then the old law will apply, and the notices as per the old law will become valid. Or if they are on or after 1/4/2021, they will be deemed as show cause notices under section 148AB of the Act. The other facet in this electronic mode of communication was the date of digital signature. As I summarized earlier also, the date of digital signature is not determinative of the date of issue of notice. But yes, the High Court held that even if the date of notice is 31st March 2021, but it is digitally signed later, then we have to take cognizance of the date of digital signature. And if the date of digital signature is later, then it cannot be said that the notice is issued prior to the date of digital signature. So therefore, the High Court assumed importance wherever the assessing officer took the option of digital signature and there was digital signature on the notices. The High Court, friends, held that in case of digital signature, the option of signing the notices by way of digital signature is an option to the assessing officer. He can either opt to issue notice through digital signature, or he can opt not to issue notice without the digital signature. The High Court held that where the assessing officer has opted to sign the notices through digital signatures, then the date of digital signature assumes importance. But where he has not opted for digital signature, then the assessee cannot plead that the notice is invalid just because it is not digitally signed. Because in this situation, section 282A comes to the rescue of the department, where it is said that if the notice contains the name and signature of the assessing officer, is electronically communicated, then it may not necessarily have digital signature. So read with rule 127 of the income tax rules. So as per section 282A read with section 127, digital signature under the substantive provisions is not a condition precedent. But if the assessing officer has taken an option of signing the notices with digital signature and they are signed with digital signatures, then as per the CBDT circulars, that digital signature assumes importance, and that will be considered as the date of notice, which cannot precede the date of issue, which cannot be after the date of issue of notice under section 148. So that is the controversy regarding digital signatures. Then friends, the High Court also held upon the DIN number. The High Court has held in certain para that DIN number is also important. DIN number assumes importance as per the new mode of communication. So every notice would need to contain the DIN number. But the date of issue will always be reckoned from the date when the email is sent to the assessee and it moves outside the servers of the income tax department. So friend, these were the various niceties of the electronic mode of communication, and the main ratio that emanates from this decision is the importance of the date of email as to when it moves outside the server of the income tax department. This, friends, will not only freezes the issue of date of issue of notice under section 148, but also assumes importance when we have to deal with issue or service of the normal assessment orders. We have to, friends, make a distinction between notice under section 148 and assessment orders passed through the faceless mode and the assessment orders which are outside the ambit of faceless mode. That is, there are certain proceedings which are not taken up under the faceless mode, like search assessments, transfer pricing assessments, and even international tax assessments. Now, insofar as faceless assessments are concerned, section 144B of the Act, subsection 6 thereof, which has even been taken note by the Delhi High Court in the impugned judgment, specifically takes note of the fact that when the order is uploaded on the portal, that will be considered as the date of order, date of communication of order to the assessee, notwithstanding email is received in that situation at a later date. So the ratio of this 148 notice cannot automatically apply to assessment orders which are being passed through the faceless mode. In case of faceless mode, it will be the date of uploading on the portal that will be considered as the date of issue or communication of the order to the assessee. So there is a distinction, friends, between 148 notice, where the email is important, but when it comes to the faceless assessment orders, then the ITBA portal, uploading of the order on the ITBA portal is important because of the specific provisions of 144B6 of the Act. Now we come to the orders which are not passed under the faceless mode, that is assessment proceedings which are not under faceless mode, like search assessments or international tax assessments or transfer pricing assessments. In that case, friends, 144B6 do not apply because they are not following the faceless assessment procedure under 144.6. In that case, friends, the ratio of this Delhi High Court decision will come to the aid of the assessee, and in that situation it can be argued that the date of uploading on the ITBA portal cannot be taken cognizance of because there is no specific provision which recognizes the mode of communication on ITBA portal. In that situation, again, section 282 of the Income Tax Act will apply, which only recognizes the mode of communication as per Information Technology Act read with section 13 thereof, and therefore it is only when the assessment order is served through email it can be argued that that is the date of service of the assessment orders. This is, friends, important because we have to day in day out deal with the issue as to what is the time limit to be counted from for filing the appeal before CIT appeal, or in case of transfer pricing on international tax assessments before the objections before the DRP. We have a period of 30 days to file the appeal or objections. In that situation, friends, taking clue from this decision of Delhi High Court, in my view, it will be the date of service of the order through email that will be considered as the date of service of order, and therefore the time limit of 30 days to file the appeal will be counted from the date of service by email and not from the date of uploading of the order on the portal. And then again, friends, the issue of digital signature we can interpolate from this decision of Delhi High Court whether or not the order is digitally signed. If the order is digitally signed and it is dated earlier, so for instance, if the date of order is 15th March, but the AO has taken an option of digital signature and it is signed on 30th March, then in my view, taking clue from this decision of Delhi High Court, the date of order will be taken as 30th March. Why it is important, friends? It may happen that the proceedings are closed on 14th March. I have filed certain reply between 14th March to 30th March. I receive order on 31st March, which is digitally signed on 31st March, but it is dated 15th March. In that situation, I can take a plea that the order has been passed without taking cognizance of the reply filed between 15th to 30th March, because the date of digital signature will be considered as the date of order. So it can be argued in that way, taking support from this decision of Delhi High Court. So in that sense, friends, this decision assumes lot of importance. There was lack of clarity with respect to date of what is the importance of ITBA server, email, date of service, date of digital signature, date of order, etc. So while this decision has been rendered to the specific controversy of date of issue of 148 notice, but at least throws light, clarifies many doubts with respect to the various facets of this new digital mode of service communication passing of the orders. So I hope, friends, you would have got some clarity on the ratio emanating of the decision and what are the consequences of this decision vis-a-vis electronic mode of communication to other mode of orders. I thank you, friends, for a patient hearing.